So, good evening and warm welcome to one and all gathered here in this Google Meet and YouTube live stream platform. Respected Director in Charge, NIT Andhra Pradesh, Professor Pramod M. Padole Sir, Registrar in Charge, Dr. Dinesh P. Shankar Reddy Sir, Dean, Research and Consultancy and Institute Innovation Council, Patron, Professor G.R.K. Shastri Sir, and our guest speaker of today's event, Dr. Prasanna Belur Sir, faculty members and students. As many of us are now aware about NIT Andhra Pradesh, which is said to be the 31st NIT in India, which was started in the year 2015, and the Institute Innovation Council was started in this institute in the year 2018. NIT Andhra Pradesh has been supporting innovation, incubation, and startup activities by conducting several ideathons, hackathons, startup expos, and field trips to make the students think about new innovations which can be extrapolated for technology transfer. In this direction, we proceed with the conduction of this workshop on the topic intellectual property rights and intellectual property management for startup. I'm very sure that this session will create greater vibrancy among the audience to become future startup founders. Now, I would like to take this opportunity to introduce the chief guest of today's session, Dr. Prasanna Belur. He is a doctorate from NIT Surathkal with 20 years of academic experience and 7 years of industry experience. He has guided 8 PhD students and completed 80 plus dissertations for postgraduate students. His areas of research includes biochemical engineering, enzyme engineering and technology, fish oil refining and preservation. He has filed 4 patents, out of which 1 has been granted and 2 has been published. He has done the technology transfer for production of non-acrid, ready-to-cook preserved, which has been transferred to NGV Naturals Industry Private Limited, Bangalore. Currently, this company is successfully marketing this product in Bangalore. He has been awarded the prestigious Corona Fellowship in the year 2019 for his Corona program, Technology Transfer Course 2013, which was held at University of Wisconsin-Madison. His foreign visits include University of Wisconsin-Madison, University of North Carolina, Pembroke, National Technical University of Ukraine, Kumamoto University, Japan, Nanyang Technological University, Singapore, United Arab Emirates University, Mahidol University, Thailand, De La Salle University, Philippines, Stellenbosch University, South Africa, and Sri Lanka. He has authored 2 books and 6 book chapters. He has a total citations of 1,158 with H index of 18, and he has completed 5 projects as principal investigator worth of 107 lakhs, out of which 3 projects are international collaboration and 2 are national projects. His contributions towards IPR activities includes intensive training on patenting, technology transfer and innovation through Corona Program Technology Transfer Course 2013 at University of Wisconsin-Madison, USA. He was the convener of Institute IPR Policy Committee, which formulated the IPR policy of NIT Surathkal in the year 2014, and this policy has become operational in the year November 2015. He has been working as the convener of the Institute IPR Committee to supervise and manage the patent applications filed by NIT Surathkal. He has been instrumental in the filing of 55 Indian patent applications and securing 15 patents for NIT Surathkal so far. He is the member of the committee which is entrusted with the responsibility to formulate NIT Surathkal technology transfer and licensing policy. With these few words of introduction, may I request Dr. Prasanna to start this session. Thank you, sir. The session is yours.
Yeah, first of all, thank you so much for giving a wonderful introduction. And before I start my presentation, I would like to thank NIT Andhra Pradesh and also Dr. Deepa for giving this wonderful opportunity to present a very brief account on IP creation, IP management. So my presentation consists of 3 parts. In the first part, I am going to discuss about IP creation. And in the second part, I am going to discuss about IP management. And in the third part, I am going to discuss about the importance of IP in startups. My presentation has around 38 slides, and I am hopeful that I will complete my presentation within around 80 to 90 minutes. And I request all the participants to patiently listen my presentation, and also you can reserve your questions till the end. Once we complete my presentation, then you can ask the questions. We can have question and answer for about 30 minutes if Dr. Deepa permits. Let me load my presentation. Is my presentation visible? Dr.
Yes,
Deepa?
Yeah. Yes, sir. It is visible.
Okay. Yeah. So let us start with intellectual property. And all of us are aware, intellectual property is an intangible creation of the human intellect. And if you look into intellectual property, there are several, intellectual properties are there. Patent is the one which is very, very important. Next one is copyrights and trademarks, trade secrets, and geographical indications. These are all collectively called as intellectual property. But patent is the one which is very, very important from the startup perspective. So I am going to discuss upon patent in this particular session. Yeah. Basically, in India, all this intellectual property is administered by Department of Industrial Policy and Promotion. And this particular department, basically administer all the IP activities which is going on in India. And Indian government has enacted several laws to help in governing intellectual property. For example, the Patent Act at 1970, 2000, 1999. And again, periodically, these acts are also amended as per the requirement. And India is also a signatory of Patent Cooperation Treaty, and it's also a member of World Intellectual Property Organization. And basically, Controller General of Patents, Designs, and Trademark is the one who administer this IPR activities, and it has this particular Indian Patent Office has separate offices for patents, designs, trademark, and geographical indications. And regarding the patent administration, the head office is in Kolkata, and it has regional offices in Chennai, New Delhi, Mumbai. And each regional office is entrusted with the responsibility of IP management, okay, and IP creation in designated states. For example, Chennai office looks after Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Pondicherry, Lakshadweep, Maldives, and Minicoy Islands. The meaning is if a person or an institution which is situated in Andhra Pradesh or Karnataka or Kerala, Tamil Nadu, if they want to file a patent application, then need to file their patent application in Chennai office. They cannot file a patent application in New Delhi office. Likewise, every regional offices, okay, has to look after the IP which is created in those regions only. So how do we, what do we get if we get a patent? Basically, patent gives us the monopoly right on that particular invention. And this monopoly right is given by the country. For example, if I get a patent in India, the monopoly right is given to me in India. And I don't get any monopoly right beyond the geographical region of India. I don't get the monopoly right in China or USA or Brazil or Japan or any other country for that matter. If I want to get a monopoly right in Japan, I need to apply the patent application separately in Japan government's intellectual property office. Similarly, if I want to secure a patent in US, then I need to file a separate patent application in United States of America. That means the patent basically gives us a monopoly right and which is highly territorial. And so I can exercise my monopoly right only in India if the patent is granted by Indian government, Indian IPO, Indian Patent Office. And this particular monopoly right is only for a limited period of time, 20 years to be very precise. And this 20 years starts from the date of application. The meaning is, suppose if I file a patent application today and my application has to go through several processes and it has to be verified by the patent office, it has to be checked by the patent offices for various criteria, and then it will go to examiner. Examiner has to look into the patent application, okay, and he has to give time for for submitting the opposition, okay. So it will be there for the public scrutiny, okay, and then the patent is granted if the application fulfill all the criteria. So this particular process may take around say 3 years or 4 years. Sometimes it may take around 10 years. But interestingly, the monopoly right is granted when the patent is granted from the date of application. So the effective period which is available for the exploiting this particular monopoly right may be available, okay, only for about 13 years, 14 years, 12 years, 10 years, okay, depending upon the time taken for the grant of the patent. There is some disturbance. Yeah. Okay. So what for this particular monopoly right is given? Basically, the monopoly right is given to encourage innovation and bring a new. Excuse me. Yeah, is my slide visible?
Sir, you can put the slideshow, sir.
Oh, yeah. So basically, this monopoly right is given to encourage innovation and bring new invention into the public domain for the benefit of society. The reason for giving monopoly right is to encourage innovation. Then you may ask, how it can encourage innovation. To give you an example, suppose a inventor comes out with a new therapeutic molecule for curing, say, cancer, and he may, come out with this particular new product, new molecule after maybe 2 or 3 years of research, let us assume. Then this is basically proved on animal models or cell line models in a laboratory. Then he can file a patent. And to develop this particular molecule and bring it to the general public, into the market, he may need to spend, or the institution may need to spend a lot of money, may need some more time, maybe another 3 years or 4 years, because all of you know, to prove that this is basically very, it is having a required efficacy, and so they have to go through clinical trials, phase 1, phase 2, whatever. Then they need to apply for, apply to the regulatory agencies, get the permission, and at the same time, they also need to, basically validate their processes through the pilot scale trials. Then they need to basically establish a factory after getting the approval, then need to produce the product in the bigger scale, then they need to basically bring it to the market. So if you look into basically the various phases involved in this particular development, okay, it may require some 3 years, 4 years, 5 years, 10 years, and lot of money will goes into this. Suppose the monopoly right is not given, then what happens is, if this particular institution or if this particular company brings out the product, let us assume the product is highly effective in curing the cancer, but within a matter of 1 or 2 years, the competitive company, the competitor, will do the reverse engineering and will bring out the same product within a span of 1 or 2 years. But interestingly, for that competitor company, if you look at the amount of investment involved, the quantum of investment involved, it's going to be very less, because they need not do lot of, initial developmental activities. Due to that, money spent by them on the product development is going to be very, very less. Okay. In that case, they will be more competitive, or they can sell the product at a lesser price compared to the first company. And through this, what happens is, the first company which has came out with an innovation, okay, may not be able to sustain the competition, and they may close down. Looking into the risk involved in developing a product, bringing it into the market, this particular patent has come into existence, and by giving the monopoly rights to the inventor is encouraged to spend a lot of money, do a lot of studies, and bring it to the market. Once the product proves to be extremely useful in the society, then they can make money, because there won't be any competitors in that particular market. To encourage such kind of innovation to come to the market, basically this patent has been brought into the it has been basically given. And not only that, there is another another phase into this. When you file a patent application, you need to disclose every information about the invention. You need to give all the required information right from the beginning, right from the experimental stage into the production stage. Okay, so this particular document will come to the public, okay, once the application is published. So, but as this particular information is available, of course, you may get a patent, but this information will remain in the patent database. So this particular information can be used by other scientists, other scientific groups, okay, to develop this innovation further. So that can lead to one more innovation. Okay, to encourage all these things, basically patent has been.
Sir, this slide is not visible.
Excuse me. Excuse me. So basically, this patent is a balance between private rights and public interest, and by bringing the innovation into the market, into the general public, the public interest is taken care. But at the same time, there are some checks and balances which I'm going to discuss in the future slides. Yeah. So what kind of things you can patent? Basically, you can patent the product as well as process, or it can be both product and the process. Okay, suppose you have come out with a
Sir, audio not visible. You are not audible, sir.
We are not getting your voice, sir.
Yeah. Am I audible now?
Yes, sir, you are audible now.
Okay. Thank you. Thank you. Thank you. So basically, there will be a provision as per Indian patent law. There is a provision for protection of biodiversity and traditional knowledge. That means, basically, if I am making use of some microorganisms which is isolated in India, or maybe I am making use of some, say plant species for producing a particular product for which I have filed a patent application. Okay, and in that case, I need to register with Biodiversity Authority of India, and I need to pay some, say I have to share some revenue with the Biodiversity Authority of India once I license my particular patent to a company. Okay, so basically there is a, through which Indian government can protect the biodiversity. Okay, so there are some provisions for even, protecting the traditional knowledge as well. And also there is a provision for compulsory license of drugs as well. For example, I file a patent application and get a patent for a, for example, cholera. And if the government of India feels that this particular monopoly right given to Dr. Prasanna, okay, may not serve the, general public, and there is a cholera outbreak, then government of India can compulsorily, whether Dr. Prasanna agree or not, this particular patent can be licensed by government of India to the producing companies, so that immediately this particular drug can be produced and cholera outbreak can be, can be tackled. Okay, so there is a compulsory license, okay, provision as well. And also there is a provision to deal with public health emergency. For example, there is a patent already available for corona outbreak, and if government of India, looking into all the aspects, feels that basically this patent has to be revoked for the public interest, yes, government of India can do that. Yeah. So what can be patented? What can be patented? Which invention can be, patented? So if you, from our perspective, we may, the invention may look very, very new, and we may feel, yes, this can be patented. But when we file the application will be scrutinized by the patent by the patent examiners for 3 important criteria, and also there is another 4. Okay, altogether 4 criteria it has to satisfy. First one is the invention has to be novel, that is new. That's very, very important. Second one is it has to be non-obvious. It has to be non-obvious, involving inventive step. And third one is it should be very, very important from the industrial perspective. Okay. And the 4th criteria is it should not fall under section 3 and section 4. So what do you mean by novel? What do you mean by novel? Okay. Basically, we, describe as per, if you go by Indian Patent Act define invention as a new product or a process involving an inventive step and capable of industrial application. What do you mean by novel? The meaning is the invention, what we are basically applying, for which we are applying the patent. Okay, the particular invention should not be, available in the public database, either in the form of a paper, or in the form of a monograph, or in the form of a newspaper cutting, or in the form of a, say a folklore, whatever be the case. This particular invention should not be available, okay, for the general public. Then only it is considered as the novel. And interestingly, this particular, say when they are checking for novelty, it is not confined to geographical location of India, throughout the world. Suppose if I file a patent for a particular product, for example, a medicine okay, a particular molecule A. This molecule A or the process to produce, suppose if you are filing for a process as well, okay, the process to produce molecule A should not be available in any database, okay, throughout the world. Then only it is considered as novel, okay. Then this can be patented. What do you mean by inventive or non-obvious? Suppose I am filing a patent application for a wine produced from, say, for example, jamun. Okay, let us assume that the production of a wine from jamun fruit is not available in any public database. Okay, it is neither available in a book, nor available as a paper, nor available in any magazine, say items or newspaper cuttings or anywhere. Still, it cannot be patented because the person who is basically an expert in that particular trade, the trade of making wine, knows very well that any fruit juice can be converted to wine. What you need is basically the right microorganism, and you ferment it. What you get is basically wine. So there is no inventive step involved in producing the wine from jamun fruit. In that case, for that invention, patent will not be granted. The meaning is, the invention has to be totally new. And second thing is, you need to prove to the patent examiners that you have spent lot of intellect, lot of energy, money, okay, in developing this particular process or developing that particular product. It is not simply a mixture of two things packed in a new say package. Okay, so you need to prove that lot of intellect has gone into this. Okay, then only they can consider for granting the patent. And the third criteria is the invention for which you are filing the patent need to be of industrial use. You need to prove that this particular product or a process is going to benefit the society. Then only it can be considered for granting the patent. The fourth criteria is several, sections. It should not come under section 3, right? So it should not fall under section 3 and 4. What do you mean by section 3 and 4? Let us look into those points. Okay. Suppose you comes out with an invention, you claim saying that you have invented a machine that gives, energy continuously without any input. And see, basically, when the examiner goes through your application, suppose basically, when you submit your application, this application is the only material available to the patent examiner. Okay, from your side, of course, they
अरे यार तुम काम नहीं कर रहा है क्या? दिमाग काम वेबिनार में नहीं कर रहा है क्या? यहाँ क्या कर रहे हो?
यार स्ट्रिकिंग करो पहले, अभी मैं गुस्सा आएंगे.
Am I audible? Dr.
Yes, sir. You are audible.
Okay. So when we submit the application, this particular application is the only input given by the inventor, okay, to the patent office. And solely based upon this particular application, they are going to carry out the examination and then they will grant the patent. Okay. And if they have any queries, of course, they can raise the queries, they can raise the objections. But again, you are not submitting your equipment, you are not submitting your product. Okay. So you can only submit the document. That's it. Suppose, you submit a document saying that, you have invented a machine, which that machine will give you, 100% performance. It will run forever. Okay. And this kind of frivolous or, say the claims which cannot be substantiated, okay, cannot be considered for patent application. Okay. Suppose, you come out with an invention. Okay. We come out with an invention for which you file a patent, and that invention is about a gambling machine, for example. Or you come out with a device, okay, which can be used for breaking a house. Okay, those kind of say inventions cannot be given patent. Okay, because they are contrary to the public order and morality. Similarly, suppose you come out with an invention which could be used for as a biological weapon. Okay, So those inventions basically, they can harm, they can pose harm to the environment or the general public, cannot be patented. Okay. And again, say while, you are filing application for genetically modified organisms, okay, then, you should be very, very careful. You should prove that it is not going to pose any danger to the, to the environment, then only it can be patented. Of course, you need to satisfy the initial three: novelty, non-obviousness, and industrial application has to be proved. Similarly, suppose you just come out with a mere discovery of a scientific principle, one particular law, it cannot be patented. You come out with a abstract mathematical theory, it cannot be patented. So, for example, you come out, you file a patent application for a new microorganism which you have discovered. You might have spent lot of time, energy, money on discovering this particular microorganism. Still, you cannot get a patent for this particular microorganism because this microorganism is a creation of nature. So you cannot claim patent for this. Similarly, you say discover a new substance, a new, for example, a ore, new mineral. Okay, you cannot file patent for this particular new mineral. Okay, so a mere discovery, okay, of a new combination, okay, cannot be patented. For example, already there is one say medicine which will cure, which will give say respite for your cold, and there is another medicine which gives respite for fever. And in your patent application, what you have done is you have come out with an invention to add them together, make a formulation, and for this new formulation, okay, you are claiming a patent, and that cannot be patented. Yeah. So you just, that's what basically aspirin is already there for say is as there as a painkiller, for example. Okay, and now you found out that this can also cure heart ailment, and you file a patent application for this aspirin. Okay, and that cannot be patented. Likewise, there are few exclusions. Okay, and if your invention comes under this particular exclusion, then it cannot be patented. Okay, for example, you are going ahead with you claim that you have come out with an invention where you have fitted a bucket with a torch. Of course, it can be useful. Because suppose if you want to fetch water in the night, okay, a bucket having a torch could be very, very useful, but you cannot claim a patent for this because it is a mere say addition of two things together. For example, umbrella with a fan, it could be useful, but you cannot claim patent for this kind of inventions where mere addition of two things has taken place. Okay. So likewise, for example, you invent a new method for producing a plant. For example, you come out with a new grafting technique. For example, you come out with a improvised soil for growing a plant. Okay, for that particular soil, you cannot claim a patent. Likewise, there are some, for example, you have come out with a new surgical process. Okay, and for this particular procedure, you cannot claim a patent. Okay. Likewise, there are many exclusions. Okay, and if your invention okay comes under these exclusions, then it cannot be patented. For example, there is a very interesting example here. Extraction of azadirachtin from neem cannot be patented because all of us know this neem has so many beneficial activities, and neem can be used for various purposes. Okay, mere separation of this azadirachtin and using the same azadirachtin for all those applications. And if your innovation involves these things, then it cannot be patented. Okay, so if your invention falls under Section 2.1 of the Atomic Energy Act, wherein your invention is related to the uranium, all these radioactive elements, this cannot be patented. Okay, fine. So from this, it's very clear to you, okay, what can be patented, what cannot be patented. Okay, and there are some disturbances, Dr. Deepa. Yeah. Please take care. Yeah. So suppose, if you want to apply for patent, okay, is it easy or how difficult it is? Is it easy or how difficult it is? All of us must understand that applying patent, okay, is a very tedious task. It takes a lot of time and it takes a lot of money. Okay. And suppose, after, first of all, you need to come out, Dr. Deepa, there is a lot of disturbance. Suppose, if you want to file a patent, first of all, you need to come out with an invention. And after this, if you want to file an application, you need to prepare the application, then you need to file it, then you need to wait for certain amount of time. And to go by my own experience, I had filed a patent application in December 2012, and this patent was granted in 2022 May. It took more than 9 years. But most of the applications will not take that much time. Generally, especially the patent applications which are filed after 2015 and 16, okay, they are being disposed very quickly. So you may get your patent granted or rejected within a matter of 2.5 years or 3 years. But in any case, there will be a time, okay, about 2 to 3 years we need to wait unless we go for expedited patent. I'll come to that. Yeah. And also it requires money. Okay. It requires money. How much? I will explain. First of all, as an Indian resident, okay, there is a law which states that we need to file patent application in India first before we file patent application anywhere else in the world. It's a rule. Okay. Unless we file application in India, we cannot file application anywhere in the world. After filing the patent application in India, with this number, we can file patent application anywhere in the world if we can afford to do that. And suppose you are basically developing an innovation or you are working on an invention, okay, and your experimental work is not yet complete. But to have the first advantage, you want to file the patent application. Is it possible? Yes, it is possible. What you can do is, if your experiment is not completed and you don't have all the details to formulate a complete application, then you can file a provisional application. Okay, you can file a provisional application, and you will get 12 months for filing the complete application. Or otherwise, already you are through with your invention and you have all the details available, you can go for filing the complete application. Anything is fine. Okay. Yeah. And while after filing the application, you need to basically file the request for publication. Suppose the inventor is associated with a educational institution and the applicant is the education institution, or the applicant is a startup, then there is a provision to file expedited application. And the meaning of expedited application is, the application will be examined, okay, in a very short span of time. It won't take 18 months, but in a matter of few months, okay, this particular application will be examined, will be taken for examination. Okay. If you file a normal application, it is not an expedited one, and you don't belong to educational institution, you don't belong to, you are not a startup, you are basically from an industry, then it is you cannot file an expedited application. It has to be a normal application. And in that case, after 18 months, your application will be published by the patent office. The patent office will publish your entire application in their database. And it will be available for the general public, not only from India, anywhere from the world. Okay. And so your information, the application information, will come to the public domain. Okay. And the right to patent will start now, and you can exercise your right provided the patent is granted to you at the later stage. Okay. Once it is published, you cannot retract you cannot take this particular published information back. Okay, it is an irreversible action. Yeah. So within 48 months from the filing date, you have if you have filed a request for examination, okay, the examination will be taken for the application will be taken for examination, and if you have not filed the request for examination, okay, the application is treated as withdrawn. So it will not be taken for examination at all. So it's our duty that if you have filed an application, patent application, we need to file the request for examination within 48 months from the filing date. That's very, very important. Okay. And once the time is lapsed, then we have already filed the examination request. Then at the right time, anywhere after 18 months, this particular application is referred to the patent examiner. Patent examiner will be the employee of the Indian Patent Office. Okay. Generally, they are highly qualified. The minimum qualification required there is either PhD or MTech. Okay. And those examiners who have the required domain expertise will examine your application. Suppose I have filed my application in the area of biotechnology. Okay. My invention lies in the area of biotechnology. Then the examiner has to be from biotechnology area. Suppose my invention is in the area of mechanical engineering, some fabrication or some mechanical product. Okay. In that case, the examiner has to be qualified in the area of mechanical engineering. Okay. So that is ensured by the patent office. Okay. Once it is assigned to the examiner, examiner will go through all the resources available. Okay. And he will go through your examination, your application thoroughly, and he will see whether all the three criteria, the novelty, non-obviousness, and industrial application is satisfied. Okay. And also he will see whether any objection is raised by the public based upon the data published after 18 months. If there are no objections, and if your application satisfies all the criteria, and your invention doesn't fall under section 3 and 4, then the patent can be granted. Patent can be granted. Okay. And basically, once it is granted, the applicant will be informed about the grant of the patent. Okay. Suppose if the examiner, okay, is not convinced about some of the criteria. Okay, some of the criteria. For example, examiner feels that the invention doesn't satisfy non-obviousness, doesn't contain lot many inventive steps. In that case, examiner may raise objections. It is called as first examination report, and this first examination report will be conveyed to the applicant through the patent attorney if the applicant has availed the service of the patent attorney. Okay. And then the onus will be on the applicant to file the response to the first examination report. And with the help of the patent attorney, the applicant can file the response, detailed response to all the queries, okay, which has been communicated as first examination report. And then the examiner will again, go through all these, basically responses. And if he is convinced, the applicant, examiner is convinced, then examiner can grant the patent. And then once the patent is granted, okay, then within 7 days, this is communicated to the applicant. Yeah. Basically, here we need to understand one very important aspect. As per Indian law, suppose I am working in an institution, in a company, then it has to be, the applicant has to be the company or the institution. For the simple reason that the inventor might have spent a lot of time and money and effort, but the inventor also might have used the resources available in the institution. In that case, okay, it becomes imperative that the institute must file the application. So they will become the applicant. And always, the patent is granted to the applicant. The patentee will be the applicant. Okay. Then you may ask what the inventor will get. So, suppose as an inventor, I am working in National Institute of Technology, Karnataka, and I have come out with an invention. Basically, I have to, hand over this particular invention to NIT Surathkal, and NIT Surathkal must file the patent application. And if it is granted, it is granted to NIT Surathkal. Okay. And during this process, NIT Surathkal, being an applicant, must take care of all the expenses. Okay. And in the future, if NIT Surathkal, commercializes this particular, patent, if NIT Surathkal license this particular technology to some company, if the revenue is generated, then that revenue will come to NIT Surathkal. As a reward, NIT Surathkal can share some revenue with the inventor. Okay. So this is the accepted practice as per Indian patent law. Okay, this has to be implemented. That's the reason most of the companies, while appointing the, employees, they, basically ask all the employees to sign this particular agreement, so that their invention becomes part of the, becomes the property of the, industries. How much money is required for filing the patent application? Okay, lot of money is required in India. On an average, at least 35 to 40,000 rupees is required for filing the patent application. Okay, and lot of fees is involved. You can see rupees 4,000 is required for basically it need to be paid to the patent office as a fees. Apart from that, rupees 400 for each page up to 30 page, rupees 800 for each extra page beyond, suppose if you have more than 10 claims. Okay, and if you want to file a request for publication, then you need to pay around 10,000 rupees. Likewise, about 40 rupees, 40,000 rupees you need to spend, okay, for filing the patent application. Apart from that, you need to, if you are availing the services of a patent attorney, you need to pay patent attorney as well. So in general, in India, if you want to file a patent application, you require at least 60,000 to 1 lakh rupees for filing the patent application. And if you want to, over and above, if you want to file a patent application in Europe, you need to spend at least 8 to 10 lakh rupees. And if you want to file a patent application in America, United States of America, then you need to spend at least 12 lakh rupees per patent application. So, this patenting business is quite expensive. Okay. So then what do we get by getting the patent? Of course, we get name, we get some, say our credentials become stronger. Okay. But apart from that, okay, the primary purpose of getting a patent is to bring it to the market. Okay. So the technology transfer has to happen. If you are unable to transfer this particular technology, if you are unable to give this technology to the right industry which can commercialize this particular invention, then there is no use in getting the patent. So every academic institution must strive hard to transfer the technology, okay, to the to the capable industry or capable individual or capable enterprise. Then only the purpose of getting a patent is going to be served. Okay. So technology transfer becomes very, very important. Getting a patent is first thing, then managing the patent and use of patent is very, very important. That's where technology transfer will come into picture. Okay, technology transfer has to happen, otherwise patent is of no use. Not only that, from the third year onwards, you need to pay at least rupees 2,000 to 2,000. Okay, for renewing your patent. So it is called as annuity. So you need to pay, okay, certain amount of money to the patent office for renewing your patent. Otherwise, your patent will get lapsed. So you need to spend money. So unless you get some revenue out of this particular invention, it becomes difficult for maintaining our patent. That's the reason we need to go for technology transfer. And by doing technology transfer, okay, we can bring the product, okay, to the market for the benefit of the society, right? So how do we do technology transfer, or how do we go for it? First of all, we need to assess the revenue potential of our invention. Fine, patent is granted. Okay, then what is the use of this patent? In the application, we have claimed that it has industrial potential, and even the examiner is also convinced that this particular invention has the potential, and the patent has been granted. Okay, but now the patent is with us, monopoly right is with us. Then how do we market this? For that, we need to basically assess the revenue potential of this particular invention, how much revenue we can generate, provided it is given to a company, provided it is commercialized. Then we need to find out who can be the prospective buyers. For example, my invention is about a anti-cancer drug. Then I need to find out what is the revenue potential of this particular drug. Okay, what could be the selling price of this particular drug, and how much money I can make in India. Then I need to find the companies which are involved in the business of producing and marketing anti-cancer drugs, and I need to contact them. Okay, and if they show interest, then I need to basically negotiate with them about the terms and conditions. Here there is one important issue. Should we license this particular patent, okay, to a one particular company or several companies? So if you are giving the monopoly right, you are transferring this particular patent monopoly right to one company, then it is called as exclusive licensing. But by giving exclusive license to that particular company, you are, giving a chance to that particular company to have a complete monopoly, and through that particular company may charge exorbitant, price for the product. Of course, they need to look at their business plan. Okay. Instead, you can also give this particular license to two companies. Then it becomes non-exclusive licensing. You are giving rights to two companies or three companies. Most of the government institutions, all the NITs, okay, all the IITs, which are funded by the government, okay, generally, in principle, going for non-exclusive licensing. Okay, because all of us, all these institutions have the responsibility to ensure that this particular invention reaches the market, and also this particular invention is priced reasonably, so that the society is benefited. Okay, so generally even CSIR institutions, basically they license the technology under non-exclusive category. Okay, and fine, now we have taken a decision that we go for non-exclusive licensing. Okay, that means couple of industries we want to give the licensing rights. Then the next question is, what is the price? What should be the royalty? What should be the upfront payment? Okay, so we need to have a clear-cut policy for this. We need to come out with a pricing model, and then we need to negotiate. Okay, and accordingly, once we come to an agreement, then we can basically enter into a licensing agreement. It has to be properly executed, and it has to be registered in the patent office. Okay, and not only this, when we license our invention, our patent to a certain company, the exclusive rights will be, of course, with the patentee. Okay, but the license to manufacture, license to market that particular product will be with the company which has entered into a licensing agreement. Suppose there is a infringement. Suppose somebody else, some other company which has not taken the license from me, okay, have started production. In that case, I need to initiate legal action against that particular company. The onus will be on the patentee primarily, and second, and the licensee company also can initiate the legal action against that. Okay, so we need to figure out the money involved in this patent protection as well. Okay, and also there could be a litigation. Say another company probably has basically is infringing upon your patent, and they are already manufacturing. In that case, you need to initiate legal action, and you need to spend money on that. Okay, so generally the patentee has to do that. Okay, yeah. So we have seen the IP creation and basically IP management. Okay, and the third important aspect is how this is going to be useful for the startup. All of us are aware.
Sir, excuse me, sir.
Yeah,
The slides are not changing, sir.
oh, sorry. Just a minute. Okay. Shall I upload again? Yeah. 1 second, please. Please wait. Is it visible now?
No, sir, it's not. Now it's coming, sir.
Yeah. Oh, sorry. Yeah. Yeah. So we have seen, basically the maintaining the patent and the legal issues related to the maintenance of the patent. We have seen. Let us come to startups. All of us are aware, startups are young companies founded to develop a unique product or a service, and startups are founded to bring it to the market. So basically, the startup itself is rooted in innovation. And if you look at, the market, there's so many startups are coming up, right? For example, taxi for sure, Uber, right? And Ola, all of them are basically startups. And all of them, started their, say their service, their activity based on the innovation. And if you look at all these startups, okay, their way of functioning is different, their product is different, their service is totally different. It is not based upon any existing model. So every startup comes out with a new business model, new template. And again, every startup is basically associated with enormous speed of growth. And for doing this, what they do is basically they take finance money from angel investors, from venture capitalists or seed funding, right? And basically they, all these things are based upon their innovations, their new business model. And if this particular business model fails at any point of time, or basically when they are convincing the angel investors, they are convincing the venture capitalists, they are going for seed funding, okay, then our crowdfunding, okay, basically they need to convince the investors that in the next year, in the second year, they are going to reach this particular stage, in the third year, they are going to reach this particular stage. So they have to give a clear idea about their growth. Suppose if their innovation is not protected, then by the time they start the second year of operation, there will be a competitor, and that competitor may copy this particular model, and they may basically start competing with this particular the company. Okay, in that case, the first startup may fail because of the competition. They may not show the assured growth rate. So to protect themselves, every startup need to go for a patent, and most of the startups nowadays are going for protection of their innovations. They are filing the patent. Based upon the patent, basically they are going for public, they are going for public funding, and they are starting their innovation. So for a startup, it's very, very important that they need to have an innovation first. Second thing is they need to file a patent so that their inventions are protected. Then only they should go for their venture. Okay, so that's the reason the invention and patent protection becomes extremely important for the startups. Yes. So with this, we have come to the final. We have come to the end of my presentation. And if you have any questions, you can note down my mail ID and you can write to me. And if you have any questions, clarifications, you can ask me now.
Now the participants are requested to ask questions. If anyone has queries, you can ask questions.
Hello,
Yes, please. Yes,
this is Makesh.
please go ahead.
Actually,
Yeah.
I have a doubt. Byju's and Unacademy are both startups whose ideas were similar.
Okay.
Are their ideas patented or
I don't have any idea about that. Okay, I don't have any idea about that. And again, see, basically, but I can tell you a little bit about this. There are, as I told you, a process can be patented and a product can be patented, or together, process and a product can be patented. And basically, this Byju's, okay, if you look at the working model, okay, the process is, they might have taken the process patent because the process involved in delivering their lecture or distribution of that particular lecture could be different. And of course, I don't have any idea, okay, about that. The product, of course, is, educational delivery, okay, and for that, probably, I don't think, they will get any patent. The process, they might have got the patent. I'm not sure.
Any other questions from the participants?
Good evening, sir.
Good evening.
Sir, idea can be a patent, right, sir?
Idea cannot be a patent.
Okay.
It cannot be patented.
If you put an idea, something like creating a product,
No, it cannot be patented because, it comes under exclusions. For example, a abstract idea cannot be patented because it comes under section 3 and 4.
Okay, sir. Thank you, sir.
Yeah.
Good evening, sir.
Good evening.
Sir, what is the recent amendment of patent in 223 years?
220. What is that?
Recent amendment of patent.
I am not a patent attorney. Okay. So I don't know about the recent
Sir,
amendment.
I will test you. I test you.
Rishabh, can you please repeat your question?
Sir, he wants to text.
Okay.
He wants to text.
Yeah, but recently there was an amendment. Let me tell you that. Okay, earlier this expedited patent application was not there. Okay, very recently there is an amendment. Through that, all the educational institutions and startups can go for an expedited patent application, and the fees required for this expedited patent application has been reduced to a great extent. Okay, through that, we can file an expedited patent application, and you need not wait for 18 months for this your application to be examined. It will be examined very quickly, and within a matter of, say 8 to 10 months, the verdict can come. Yeah. I think I have answered, Rishabh. Yeah.
Any other questions from the participants? So there is a question about patent database.
You can go to Indian Patent Office database, even Google database. Yes, there is one more important point which I forgot to tell you. Okay, can we draft a patent application? Normal question asked by many researchers, okay, many inventors. My answer to this is it's better to take the help of patent attorney, for the simple reason that every patent application is basically a techno-legal document. Technically, we might be very, very sound. Technically, we might be very, very competent, but the knowledge of patent law is very limited to most of the inventors. That's the reason, okay, it is better to avail the services of the patent attorneys, designated patent attorneys, okay, so that your techno-legal document becomes extremely strong. The possibility of getting the patent is going to be more, okay. That's the reason, we need to avail the services of the patent attorney. And when we, approach the patent attorney, normally, before we file the patent application, we need to go for prior art search. Okay, and through prior art search, okay, we will assess or we will find out whether our invention, okay, is novel or not, whether the invention or the information related to our invention is already available in the database, public database. Okay, and basically you are aware every PCT signed country, okay, patent cooperation treaty members, okay, have maintained their patent database, and it is mandatory for all the signatories of this particular PCT countries to upload their patent information in their database. Okay, and generally these patent attorneys will be having access to all these databases, and by taking the help of patent attorney, we can examine all those databases and ensure that our invention is novel. Then only it is worthwhile to file the patent application, because once we file the patent application, already we have spent some money. After that, we need to spend money for filing the examination request. We need to spend some money for filing the response to the first examination report. Likewise, we need to spend a lot of money. Okay. Suppose if you are convinced that your invention is not novel, then you can drop the idea of filing the patent application there itself. You can save the money and time. That's the reason it's always advisable to take the help of patent attorney. There are many patent attorneys available in India. Highly competent patent attorneys are available in India. Maybe we need to take the help of those patent attorneys. And most of the institutions, including NIT Surathkal, IIT Madras, IIT Bombay, IIT Kharagpur, okay, have basically empaneled certain patent attorneys, and all of us basically avail the service of those patent attorneys while filing the patent application.
Sir, I have two questions, sir.
Please go ahead, madam.
What is the difference between patent granted,
Okay.
patent published?
Basically, when we file the application contains all the details about our invention, and also application contains claims. Okay, what are we claiming? Okay, then this particular application is published by the patent office. It is like publishing a paper. It's available in the patent database, Indian patent database. Now it is available to the general public. Now the public can go through your application, and if they have any objection to your application, and if they feel that the application what we have submitted is not novel, already you are copying this particular invention from a folklore or a traditional knowledge, a information or a practice, being being used by tribal people, for example, then they can file an opposition. And if the examiner, feels that your application is not novel or not inventive, then they won't grant a patent. And once the patent is granted, it is now very clear that it satisfies all the four criteria, including novelty and non-obviousness and industrial application. Okay, so publication is simply bringing out this particular paper into the public database, whereas the patent will give you the monopoly right. Okay, so publication will not give you monopoly right, but you will become eligible. You will become eligible for the monopoly right. Okay, but unless the patent is granted to you, you will not get the monopoly right. I think I have answered, Dr. Deepa. Did I answer you?
Yes, sir. Yes. Sir, actually, what is the time limit? Within which time limit we need to apply for the
Examination.
examination?
Madam, it is advisable that we, file the examination request as soon as we file the, application. Otherwise, what happens many times, it so happens that, the attorney may forget to file the examination, though you might have told him. So it is better to ensure that the examination request is filed as soon as you, file the application. Okay. Yeah. But many times, industry will wait till this patent application is published. Okay. And if there is, enough opposition, then they will, what they do is they will not file the, request for application, by which you can, application for examination, by which they can save some money. Okay. Yeah. If you are really convinced about the novelty, then you can file the request for examination as soon as you file the application.
Thank you very much, sir.
Yeah.
Any more questions from the audience? Shall we wind up? I think sir has answered almost all the questions, and he has also addressed all the aspects in his presentation also. Any other questions from the audience?
Madam, can I ask one question, madam?
Yes,
Please
yes,
go ahead. Yeah.
please.
Sir, if idea is cannot be patent, if I am doing on that, like doing work on my idea, so provisionally can I apply for patent, sir?
Yeah, you can see, the point is you can file a provisional application. Okay, you can consult a patent attorney and file a provisional application. But there will be a clause within 1 year. You need to basically work on your idea, develop a prototype, or develop, or generate the data, generate the experimental results. Okay, and using all those things, you need to file the full patent application. Okay, within 12 months. It's mandatory.
Duration is 1 year.
1 year, yes.
Yes, sir. Thank you very much, sir.
Yeah.
Thank you, sir. So I'll wind up the session, sir, with the vote of thanks.
Sure. Yeah, please go ahead. Yeah. Shall I stop presenting?
Yes, sir. I think it's with the
Okay.
thank you slide here.
Yeah, yeah.
So thank you very much, sir, for giving us insights on intellectual property rights and its management in startup. It is my responsibility to vouch the vote of thanks. To first and foremost, thanks to our director, sir, registrar, sir, and dean, research and consultancy for rendering full support to conduct this event. Special thanks to the web and network team for their continuous support till date in rendering the YouTube live streaming. Last but not the least, I thank the participants who have actively participated in this session. Thank you very much.
Thank you so much for giving the opportunity. Thank you, one and all.
Yes, the participant can leave the session. Thank you very much.
Shall I stay back or shall I leave?
No, you can leave, sir.
Thank you. Thank you.
Thank you very much, sir.
Yeah, yeah.